Hi, I'm Anthony Alder from Alder IP, and welcome to another episode about IP. Today we're going to be talking about trademarks and the trademark process overall, to give you a bit of an understanding of how the trademark process works not only in one country like Australia, but also internationally on an international basis, because it's quite a complicated system. Where we start usually is we're Australian attorneys, so we're going to start with an Australian application. Now, an Australian trademark application follows the same process as what most national trademark applications follow. You file it with the Trademarks Office, then after a certain period of time, a trademark examiner from the office will look at your application and determine whether it meets the requirements for being a trademark. Primary requirements are that it has to be distinctive and not conflict with an existing trademark. And that's most of the rules in most of the countries. Some of the countries have some unusual additional rules, but we'll get into that. Once your trademark's filed, generally in Australia, we get an examination report about the 6-month stage. We overcome the examiner's objections, it's published, and it's open to public opposition for 2 months, and then it's registered. And it's a very simple linear process. The problem is when you go talk about overseas trademarks. Now, if we file an overseas trademark, we need to file the overseas trademark before 6 months from the filing date of the Australian application. And this is really important because if we file that application within those first 6 months, we can actually claim the Australian filing date backwards. So you're basically backdating the international filing date on your trademarks to the original filing date in Australia, which is really important, and it stops people from stealing your trademark overseas. Particularly if you're running a business in one country and you're starting to promote your business in another country, it's very easy for people to steal your trademarks, and it commonly happens with people spruiking their businesses in the USA, Europe, and China. The most common way that people file trademarks overseas at the moment, particularly if you're picking more than one country, is to use a system called the Madrid Protocol system. And what this is a very fancy system that uses a UN organisation called WIPO. And what we do is we file an application directly with WIPO, and then WIPO funnels your application into the individual countries on our behalf. Those countries then report back to WIPO, and WIPO translates it nicely into English and then sends it back to us. And we only have to deal with one organisation. We only have to deal with WIPO, which means we don't have the logistics of dealing with local agents. It also streamlines the whole process and makes it a lot simpler and a lot cheaper for applicants to file trademarks overseas. It also gives you a lot more dependable outcomes. A Madrid Protocol application is at the moment, it's fileable in over 180 countries, and the list is growing steadily. It's a very good system. It does have a few bugs in it, and the biggest bug is that it has to be based on an original application in your country. So if we filed it in Australia, the Madrid Protocol application has to be based on the Australian application. If the Australian application lapses or dies for some reason, the Madrid Protocol application will die as well. So we've got to make sure that we keep that Australian application or your first primary application alive. The other way to go about filing internationally is to file in each individual country. This is more the traditional way of doing it outside of the WIPO organisation. And we can directly engage agents in particular countries to file a trademark on your behalf. We administrate the process and we still can claim the priority date from the Australian application. The problem with this is costs. It's a much better system to do it because we get to use local agents, but the cost is often double to 3 times the cost of what it would be to file through a Madrid Protocol system. Those applications don't get treated any differently to what the Madrid Protocol system does, and they're all subject to local laws. So quite often you'll get differences in examination processing, particularly between China, the USA, and Europe, because their standards of examination are quite different. The European examiners often leave conflicts up to individual applicants to resolve. In China, it's much more that the examiner makes a judgment call and you really can't change their minds on what their judgment call is. And in the USA, you have a slightly different process again, where they're much more rigid about the list of goods and services than what we would be in Australia. I hope this helps. And if you need any more information about trademark processing or trademark registration, please feel free to contact myself, Anthony Alder, or my team at Alder IP. Thanks for listening.